Hello and welcome to a fresh episode of Legal Wrangle. In today's episode, we will be covering the latest judgments of the High Courts on the apparently struggling GST. Let's now proceed to our first case. The first petitioner is a registered charitable trust. It challenged an order levying GST on the one-time lease premium charged by the City Industrial and Development Corporation of Maharashtra Limited while giving out plots of lands on lease. Hence, the first petitioner sought that a direction be given to the respondents to not to levy GST on the members of the first petitioner.
The court noted that provision of taxing statute would have to be read together in harmony so as to understand the nature of levy and its purpose. The court further observed that no activity of nature mentioned in the inclusive provision could be left out of the tax. Once the law, in terms of substantive provision and schedule, treated the activity as the supply of goods or supply of services, particularly in relation to land and building and including a lease, such consideration as one-time premium would be measure on which tax is levied, assessed and recovered.
The court then noted that the CITCO was not operating with the objective of earning money but rather with the objective to develop the area. Also, the purpose of setting up a township was achieved by more people wanting to live in the area in lieu of various amenities provided. Thereby, the court held that given the activities of the CITCO and its status, it could not be said that lease premium would not attract GST. Hence, it could not be said that the activities performed by sovereign or public authorities under the provisions of law, which were in the nature of statutory obligations, are excluded from the purview of the present enactment. Therefore, the writ petitions were dismissed. The petitioner here is an individual who filed the present writ before the High Court seeking to bring diesel and petrol within the ambit of GST. He submitted that although the international market price of crude oil per barrel is very low, an exorbitant increase in the selling price of petroleum products directly affects the common man. The petitioner further stated that most goods were transported by road and so an increase in the price of fuel would increase the sale price of the commodities.
The petitioner also submitted that not including diesel and petrol within the scope of GST would drive up to the prices of essential commodities. He claimed that this to be all, the more reason to bring diesel and petrol within the ambit of GST. He also claimed to have submitted a representation to respondent and that in spite of it being received and acknowledged, no response were forthcoming.
On hearing the submissions, the High Court held that whether or not to bring diesel and petrol within the GST was the prerogative of the central government through the GST Council rather than of the High Court. It further held that the well-settled position in law dictated that it was not for a court to take a call as to whether or not a particular policy or some decision taken in furtherance of such policy was fair. The High Court further held that in such cases a court could interfere only if a policy or decision was found to be arbitrary, malefic, contrary to provisions of law or based on an irrelevant consideration. It also pointed out that the GST Council was represented by the state governments, thereby their views would also have to be taken into account before deciding upon whether or not to bring diesel and petrol under the ambit of GST. Hence, the High Court dismissed the present writ.
The petitioner herein challenged Section 140 of Central Goods and Services Tax Act 2017. Section 140 of Act pertained to a transitional arrangement for input tax credit. The petitioner herein claimed that Clause 4 prescribes time limit for transitional credit availment and that it violated the mandate of Article 14 and 19 of Constitution of India.
On hearing the matter, the High Court held that CENVAT credit is a mere concession which could not be claimed as a matter of right. It further held that under the present laws, claiming CENVAT credit is a restricted or conditional right. Thereby, if the existing law itself imposed the condition for its availment, it could not be said that such rights under the existing law could have been availed of irrespective of the period provided therein.
The court also held that the period or the outer limit is prescribed in the existing law and the rules for availing Senved credit were enacted accordingly. Thus, it observed that in such circumstances, the imposition of condition-wide Clause 4 is not arbitrary, unreasonable and violative of Article 14 and 19 of Constitution of India. The court reiterated that where the right to avail of Senved credit was itself conditional and not restricted, or was in absolute, then the right to pass on such credit could not be claimed in absolute term. With such observation, the court dismissed the writ petition.
The SSE company in the present case challenged the second proviso to section 140 of the Gujarat GST Act as being ultra vires. The SSE claimed that such provision imposed a restriction on a dealer for claiming credit of the taxes already paid under the VAT Act. The SSE further claimed that such provision deprived a dealer of its vested right and that the statute acts retrospectively and imposed an unreasonable restriction.
On considering the SSE submission, the High Court directed that notice be served to the concerned parties returnable by 19th April 2018. The court also held that since the act in question was being challenged as ultra vires, a notice also be served upon the Attorney General.
This brings us to the end of this episode. Thank you for watching this episode of Legal Wrangle on GST. Please stay tuned to TIOLtube.com for more videos on issues relevant to the field of direct, indirect and corporate taxation. Please also feel free to share your views with us at editor@TIOL.in. Have a good day.